and I'll welcome you to today's webinar on the legislative impact for what Colorado landlords need to know. Before I introduce everyone, kick it off, can anyone just say good morning, good afternoon in the chat? I want to make sure you can hear us, and see the screen. So let me know in the chat, please, once you can hear us and see us. Perfect. Alicia, Sabrina, Vincent, Laredo, Lauren, everyone, good morning. Love it. We got a jam-packed webinar. This is actually one of the highest ones we've had all year. So keep the chat box going. Put your questions in there. We'll do the best to answer them. If not, we'll get to them hopefully in the future. But we'll kick off the webinar. So again, my name is Chris Lopez. I think a lot of you know me, but I am a local landlord here in Denver and also run the Denver Real Estate Investing Podcast. I'm joined by two great gentlemen this morning. Brandon Schulten, who's a local landlord and also the owner at Keyrenter Property Management of Denver. Glad to have you back in the studio, Brandon.
Great to be here.
All right, and my second guest is Darren Everett, who is the owner of the Two Arrows Group. So he is a local investor, and also he is one of the founding board members of the Workforce Housing Coalition. Good to have you in the studio, Darren.
Yeah, thank you.
All right, so as we kick things off here, this is a great joint webinar we're doing between, Keyrenter, who helps a lot of landlords manage their properties, and then the Workforce Housing Coalition. Darren, the Workforce Housing Coalition, some of our listeners know who they are, some don't. It's a new coalition. What is it?
Yeah, so it's a group that was formed last year. So this was our first legislative session together. And it was really formed to bring together what I would call sub-institutional property owners and operators that have maybe traditionally been represented by the apartment association, wherever you hail from, Denver, Colorado Springs. But generally our issues are focused on one specific to smaller owners, investors, Colorado specific owners of properties that are, call it 5 to 100 units in size or so, that might have a different set of needs than the larger institutional corporate real estate owners. So, and our focus is also to not go out and kill every bill that we think might be harmful for housing policy. Our focus is to really partner with legislators to modify or amend or educate on the why behind some of our needs and requests. So hopefully this session be really viewed as a partner for legislators, regardless of how progressive or conservative you might be.
Wonderful. And I want to drop the website here in the chat, whccolorado.com. Go check out the website, join the email list, but it's a great coalition. Stay tuned, stay plugged in, because while it's their first year, they've got some great people on board and a great mission. All right, so we will jump into it. And what we're planning on today is we've got a few bills to talk about. We're going to talk about briefly what they are, but really talk about the impact. So what landlords need to know how to navigate it, and also talk about some of the unintended consequences for people's residents out there. But Darren, we were talking about this a couple days ago, just about the velocity of bills that have been coming down the pipeline. Can you kind of give us a perspective of the last couple of years versus the last couple of decades?
Yeah, I mean, those of you that have been doing this or in this business a while know that there wasn't a lot that was ever really introduced pre-COVID that was of major consequence to our space. But post-COVID, for a variety of reasons, saw a variety of rental bills get introduced, and they've almost kind of, as this chart will show, have grown exponentially. And so I think the total count over the last 4 or 5 years is about 40 bills or 40 pieces of legislation or regulation that our industry has had to digest and sort through. And regardless of what business you're in, I mean, that's a lot. And it's a lot. I'm glad Brandon's here, but to understand if you're, an unsophisticated operator or you don't have some huge management company representing. So the big message I give to legislators a lot when I talk to them is like, hey, it's not just your one bill in isolation. It's the sum of all these bills and the impact that it's had on operations and, most importantly, renters. I think that the unintended consequences, the volume of bills, has ultimately hurt the end user, which is our customer, which is the renter. So that's something the Workforce Housing Coalition is going to work pretty hard on this year, is to try to hopefully reduce or consolidate the volume of bills that we're tackling.
Yeah. Brandon, you want to add anything on there? I know you've been property management for 10 plus years now, so you've seen some changes.
Yeah, like we didn't fear the legislative session in those first few years. It was like kind of off my radar because it just there wasn't that much going on. And we historically we're kind of a landlord friendly state. And yeah, this graph kind of shows how that's changed in basically 4 or 5 years. It was nice to see at least that trend didn't continue up in 2025. I don't know what to chalk that up to, but at least we saw a little bit of a pullback in just the amount of bills proposed housing that are housing related, and then the amount that were ultimately passed. 2 of those bills were vetoed. I think there were only 11 total bills that were vetoed out of about like 490 some that were passed, and 2 of those were in housing. So that's at least a good sign that it seems to be on the governor's radar that we got to be sensible about what we pass here, and there's kind of understanding the complexity of putting that much forward for landlords.
And one thing I'll add on that I've learned from reviewing all these bills is that I think the last couple of years worth of bills used to be carve outs for smaller landlords. All our listeners, they manage 5, 10, 15, 20 of their own properties, and it used to be like, hey, you're a corporate landlord, hey, you got kind of like you have to comply with this. Now all these bills, it's just, hey, here's a rule. Everyone complies, whether you got 1 property or 2,000 properties.
To my knowledge, there was not a single bill this year that had a carve out. Yeah, that was a big thing kind of in maybe 21, 22, but that has largely gone away.
Yeah, and I think from a lot of the people I know in this webinar, a lot of them are self-managing landlords. So make sure you are plugged in this. And today's webinar is a great place to be aware of what's going on, because you want to stay and comply with the law for obvious reasons. All right, moving on to bill number 1 here, HB 25-1240, protections for tenants with housing subsidies. Brandon, what is it and how does it impact everyone?
Yeah, so like if you follow this stuff closely, this one has been a saga of, we had the CARES Act come through post-COVID that was trying to kind of protect, this eviction wave that they thought might be coming due to all the impact from COVID. So one of the things they immediately implemented in the CARES Act was this 30-day requirement for posting rent demands. Essentially, it was 10 days before that. Used to be 3 days a couple of years before that, but bumped this up to 30 days. So if a tenant's late on their rent, you have to post a notice and give them 30 days to cure that. In the CARES Act, basically their reach on that was limited to people with federally backed mortgages. So this carried on post-COVID, and there was no obvious, they didn't include any language of when this was going to end, or it was just unclear if this was still going on. So this went all the way last year to the Supreme Court in Colorado, a case basically trying to the dispute was about, is the CARES Act still in effect? Is this still a requirement? And the Colorado Supreme Court ended up ruling that it was still did apply. So then we saw some stuff at the federal level of them. There was a possibility that they were going to add some language and create some clarity here. And then in this legislative session, Colorado basically passed this to be like, nope, this is forever something we want a part of our laws or whatever. So, but it also had some nuance and that kind of thing. So we'll hit on a couple of those here. But basically, if there's anything, whether it's a federally backed mortgage, a tenant's on a subsidy in the property, anything like that, then you hit this requirement, and now you're required to give a 30-day notice for any rent demands. For compliance demands, it's still 10 days for most of Colorado, except for Weld and Larimer counties. So those are kind of the high points on it. I don't know if you.
Yeah, this is one we worked on kind of late in the process, but the 30-day in our portfolio, the difference between a property on a 10-day and 30-day, the delinquency situation is dramatic. I mean, it's if you give someone 30 days effectively to pay their rent, it often clicks them into the next month's of rent owed. So it, for a lot of workforce housing communities, puts people 2 months of rent behind, which is past a point of no return for a lot of people that live paycheck to paycheck. So of all the things we've had to grapple with in our industry, I would say the switch to the 30-day has been the most damaging for renters as I've seen it, especially ones that live kind of at the lower end of the earning spectrum, in that it removed the guardrail of requiring you to pay your rent in the month that it's due. And so in the olden days, like Brandon said, when there was a 3-day, you used to be able to take partial payments because you would redemand on the balance and you'd be able to have somebody pay you kind of beginning of month and mid-month. 10-day, you could sort of do that and make arrangements and work with people. 30 days, that's impossible. You can't take a partial and then 30 day. That would start a huge, long process. So this is one where I think some confusion and some more education. I'm hopeful that in the years ahead, we can roll this back or work with legislators to try to get back on a 10-day demand. But the 30 days here to stay for the Fannie, Freddie, and HUD or federally backed mortgage properties.
And Brandon, you were saying before this webinar that when you go out there and post eviction or post something, you actually research with your property owner what type of mortgage they have, correct?
Yeah. I mean, the difference between 10 and 30 days, like Darren was saying, is such a big deal that it's worth it to us to figure out. We're not just going to assume every property's on it, because there are a lot of homes on, loans with individual banks or that kind of thing. So it's worth for us doing the homework to see if we can serve a 10-day.
Yeah. Now, again, if you're a self-managing landlord out there, make sure you're aware of this. If you have a property manager, make sure that you're on the same page as what type of mortgage you have on there. A comment in here that Becky shared a few minutes ago as we're talking about the lack of carve-outs. She made a comment saying it's even more onerous for licensed Colorado agents managing their own rental properties. And I think that's a great thing. If you are a licensed agent, you have a higher duty to the public. So another thing to keep in mind, since we have many agents who are also investors on here. All right. Anything else you want to say on this bill before we move on, guys?
No.
All right. Actually, there was one question. I don't know if you know this. This might be too nuanced, and we can't give legal advice, and we can't get into too technical details on here. Jess says, "What is the compliance requirements in Larimer and Weld County as far as like the posting days?"
Yeah, just the difference there was what we looked this up this morning is that you still need to go 30 days for demands for compliance. So that means there's some lease violation that's not unpaid rent. It's noise violation, or they have got the wrong car parked there or whatever. Then you still have to give them 30 days to correct that. In every other county, it's just 10.
Okay. Maria asked, can you explain why you need to only accept the full payment and not a partial payment?
Yeah, essentially, if you accept a partial payment, it just resets the whole timeline. So you are entitled to accept a partial payment. That's at your discretion. But I think what Darren was getting at is like when that restarts the clock on 30 days, that's just a huge burden for it just becomes untenable to do that. You don't want to restart that process. So you basically say, no, we're not taking your payment. We need the full thing in order to.
And then that probably gets people more into that downward debt spiral you were talking about, where it just kind of lose for everyone then, right there.
That's right.
Yeah. All right. Does the 30 days apply only for federally backed and subsidized, or just one?
Just either of those.
Either. Yeah. Great. Great. Keep these questions coming. I see some other ones. We're going to cover these in future slides on here. But House Bill 25-1168, Domestic Violence Bill. What is this, Brandon, and what's the impact?
I would say this is the one that just has got us the most nervous, probably, in terms of it feels like it's kind of ripe for some potential fraud that could leave the landlord in a really bad situation. So I can certainly see the intention here, and it's offering some protections for victims of domestic violence so that that incident doesn't lead to them being evicted. Basically how this functionally works is it expanded, and we already had some legislation around handling domestic violence, so this isn't totally new, but it expanded how someone needs to prove that they've been a victim of domestic violence to their landlord. So this can be they just need verification from a qualified third party, and they define that as a medical professional, a domestic violence advocate, clergy, law enforcement. So any of those will do. And now on our demands, we have language specific to know your rights, tenant. If you have been a victim of domestic violence and that is why you're late on your rent or whatever, then please contact us to understand your right, or something like that. So
when you say post, you mean when you post and deliver the eviction, right? You're having specific language for this as well?
Yeah, just the demand for rent. You have to let them know, if your reason for not paying rent is this, then we got to talk. So then that basically, if they let you know that yes, and they provide some kind of proof through one of these people, then you're required to offer them a repayment plan. And they provided some specific parameters that kind of strike me as a little bizarre, but basically you have to set up a payment plan that's in writing, that it has to include payments of at least $25 each month, and it can be up to 9 months long. So yeah, I would say this is going to get really tricky. And even for us, if this comes up at all, we will definitely be working with our attorney on understanding what we can and can't do, and all that. But yeah, I think the big takeaway for landlords is just know that, like, if domestic violence comes up, if that's brought up, like, your radar should be going off, like, okay, let's be careful. Let's make sure we are very by the book on how we approach this.
And you mentioned the landlord action bullet point, review your lease clauses as well. Have you updated your leases specifically for this bill?
Yeah, so I mean, we even know in advance to carve out time for those on our team who are going to be digesting this stuff and updating, because some of this stuff, as soon as it's signed, it's like in full force. So yeah, I don't know the exact changes we made related to this, but I do know the one big thing was, like, now the demand notices have that right at the top.
Yeah, any comments or anything on here, Darren?
No, I mean, this is an example of one where I'd say, yeah, very well intended, for sure. I think we could all get behind the why on this bill.
Yep.
But the complexities in our business and setting us up for fraud is what we all have to be careful for here.
Great. All right, we're going to move on here. And just as a reminder, and also a shout out to Brandon and his Keyrenter team, they started doing what they call portfolio health audits. I think they're kind of like Q4 last year. Q1 really started helping people do it. But with a lot of these, new complexities, a lot of landlords, want to make sure their portfolio is doing well. And a lot of people also are just interested in getting, a professional full-time property manager to help manage everything as well. So if you have any interest or questions on your portfolio, reach out to Brandon, the Keyrenter team. There's a QR code you can scan. We'll share the link later as well. But they'll do an overall consult with you. They'll help you understand everything about, hey, what options with your property. And they can't give legal advice on there, but also look at, hey, how is it performing from a rental market perspective? What can you do with utility bill backs? Do you need a Denver rental license check? I'm still amazed at how many people don't have their Denver rental license. So if you are curious about how your portfolio can be optimized, or want to talk with a property manager in taking over your portfolio, connect with Brandon. They have helped a lot of my clients who are self-managing landlords kind of be like their resource. So if you have any questions, Brandon's team is an amazing one. So thank you for doing that, Brandon.
Yeah, thank you.
Did I miss any key points on there?
No, that's great.
All right.
We had a question here. Is it clear that this applies only to the names listed on the lease? In other words, if a tenant has a boy girlfriend not on the lease, and they were living in the property, do the protections of the spill not apply to them? Yeah, probably a great question for your attorney. It was specific that this is to protect victims of domestic violence and their inability to pay rent as it relates to that. So as I would understand it, if someone who's not on the lease were to be abused, I don't know how that would be relevant. But
okay, again, that is area you definitely want to check with your attorney on. All right, moving on to House Bill 25-1090, protections against deceptive pricing practices. What is it, and what are the consequences, Brandon?
Yeah, so I think this is the only bill we have in here that wasn't actually under housing, but it applies. So basically, this is like part of a whole wave we've seen of these kinds of things across lots of different industries. But basically, they're trying to get rid of, a lot of bait and switch kind of things where it's like advertise a really low price and then there's all kinds of things tacked on at the end. As a consumer, I like that they've done this with like ticket sales and things like that. It's just felt like it's made things more straightforward. So I can certainly, again, I can get behind what they're trying to do here. For us, this didn't represent like a big change in practice or anything. We were, trying to be real clear up front on what the fees involved with renting this property are. But it's another one where there are some unintended consequences here. I don't know if, Darren, you have anything to share on your experience with this, but you just got to be careful. There's some specific language around what you can and can't charge, and what they would consider kind of a, violation of this.
Yeah, I would say within the 3 or 4 property management companies that we work with, there's still, it seems like everybody is still trying to understand this bill, candidly, especially with regard to utility bill backs and any common area fees that you might charge. Many of those were standard practice for, since I've been doing this 15 years. So I think there's some confusion there. To Brandon's point, I'm on board with, the original why behind this bill. We were seeing, I think, some, candidly overreach on some things where there was some pretty aggressive markups by certain landlords and institutional landlords. There was, valet waste was one for everybody to easily understand, where it's pretty easy to get upset when you're, paying for $40 a month for trash service that may or may not happen with regularity. So those were some of the headlines that were on the real estate side of this bill. Rolled up in that has come RUBS billing, common area billing, et cetera. And so I would say this one, I don't know if anybody's an expert on this yet, but definitely work with your attorney and get their take on what you can and can't do. And make sure, I would say, that your lease matches 100% what your bill backs are, for sure. But the unintended consequence on this is that rent's going to go up. It's just going to push whatever revenue stream was coming from the bill back onto rent. And I think that was definitely the intent of this bill.
So this one doesn't go live till January as well. So this is one where, the dust is still settling and attorneys will kind of sort this out and figure out exactly what it means and that kind of thing.
But anybody on a renewal coming up, you got to kind of think through this, because if you're renewing people now, you got to roll your leases to comply come January.
Yeah.
So Carolyn asks, can you confirm all fees are assumed by the landlord and not renters anymore? I don't think this is saying the landlord has to pay all the fees. It's just about disclosing.
Yeah,
fees,
it's
correct?
not like this went into like, okay, you have one number and you cannot charge a penny over that in any way, shape, or form. It's not doing that. I think at one point there was might have been some push for that kind of initiative here, but the final state of the bill is not that.
So you asked a great question on trash and some of those. There are some specifics listed in the bill, and there's some areas that are seemingly gray or unknown. Common area utilities is an example. Like if you have a master metered building and you're billing back, there seems to be some confusion on what you are allowed to do and not to do. So I think this will play out over the next month or two with mostly PM companies are going to have to take the lead and decide what they're going to do for their clients.
Yeah, so stay tuned. And as we get more clarity, Keyrenter, the Workforce Housing Coalition, will share the best knowledge we know. But of course, stay tuned.
But again, just to add this one, I mean, you're seeing a theme here. Like these are complicated bills and aren't very clear. And so you add up 5, 6, 7 of these in a session on top of the 30 or so that you've already had to sort through in the last few years. Like our business is becoming inherently complicated and expensive, which obviously will start to create pressure on pricing on the other end of that lever. So
there's some of the tricky stuff on this too is like there's plenty of leases we've signed through, or any landlord has signed year to date that are a year or more longer. So you have this problem too of like leases that may be non-compliant that extend into the period of when this is going to be required. So yeah, that's another tricky part just in the rollout for operators too.
House Bill 25-1249, tenant security deposit protections. Brandon, what is it and what are the consequences?
Yeah, so we've seen a lot around security deposits the last few years. This isn't the most extreme in terms of like how it changes day to day of what you're going to do, but it provides, some of it like adds teeth to kind of the trouble damages and what constitutes bad faith from a landlord. So certainly, I don't know if you saw that, but it kind of like seems to put us all on notice of like, this is because a lot of things, trouble damage has been around as long as I've been doing this, but like most judges won't award it, even if it goes all the way to there. If it just seems like it was kind of this could have gone either way, even if they side with the tenant, they won't award trouble damages. That has been my experience. So I don't know if this changes that, but it's like now there's a formula of if you charged 125% of what the actual costs were, then that trips into like what they're calling bad faith or something like that. So so that's one aspect of it. It's adding more language around normal wear and tear, which is frankly pretty helpful because so much of this stuff was just up to our discretion, and then you have to kind of guess at how that might be interpreted by a judge. A little bit of that. There wasn't a ton, but like one thing, for example, they say if carpet is 10 years old, you are not allowed to withhold anything for that beyond 10 years. Paint, it had some language around like you can only charge for the paint that was required in order to correct whatever damage there was or something like that. So it's essentially like, yeah, you can't say, well, we tried to match the paint, it didn't match, so we just repainted the whole house and the tenant's paying for it, kind of thing. But it also, one part of this is it does allow the tenant to request a walkthrough of the property. But I don't know if this was something that the workforce housing was involved in, but
we didn't lean in on this one. I mean, honestly, this is a lot of like standard operating procedure for quality management. And I would say if you're an owner operator, just be really tight, probably worth reading this bill and make sure your standard policies are, conforming, which is documenting the condition at move-in with move-in checklist and supporting pictures, and then doing the same on when someone leaves, and then saving all receipts and costs should generally put you in a good spot here.
Yeah, and making sure you're not charging things that like you didn't actually make the repair, you just got an estimate for it or something like that. I don't think practices like that feel like they're kind of outdated even before this bill went through, but this clarifies some of that.
A question from a few minutes ago: can you withhold the security deposit in lieu of back rent?
Yeah, so that's one of the things, again, this is an example of a bill where I would have loved to have sat with the sponsor early. I mean, Colorado generally for apartments anyhow is a pretty low security deposit state, that's like a market thing. So in Denver, like in our portfolio, I think deposits range from $250 to $750. Most are probably around $500. So your move out charges, your last month's utilities, standard stuff often eat up, and most people are like, yeah, cool, just put my deposit towards that, or it first gets pledged to rent, is the priority. And then damages are like way down the list, usually cleaning, etc. So in our operating experience, I mean, deposits usually get pledged to, especially if you're delinquent, go first to rent and other charges before they hit this. So it's like, I don't know. This one wasn't, in my opinion, this wasn't a huge focus for our group.
Have you guys seen any, like in your respective portfolio data, like, amount of security deposits, withholding like increase or anything like that? Or is it too early to tell?
I think it's too early to tell. I mean, in general, we would love to give security deposits back. That means the resident left the apartment. We're not trying to hold security deposits. So I would, love to see everybody get their deposits back. And so if this bill pans out that makes everybody a better operator, then I think this bill was fine. We didn't have a lot of issues with this bill.
Yeah. And I think that's kind of the approach that you have to take right now is you can't go into these sessions and just try to make movement on every single one of these. Like some of it is being like, we'll get behind that bill.
A question: what about if the renters are smoking in the unit and everything stinks of smoke, and the lease said no smoking of any kind in the unit, presumably cigarette or marijuana?
Yeah, I don't know exactly what the question is there. Some leases used to have like, there were penalties for doing something like that. I think those kind of things have gone away. So yeah, again, you can probably address the smoke smell. In some ways, you could use an ozone machine and repaint and those kind of things. I don't know exactly. Yeah, probably a good question for an attorney. I'm not sure on that.
All right. Moving on to the next bill, House Bill 25-1236, tenant screening and source of income. What is it, Brandon?
I'm really curious to hear from Darren on how much you all see these portable screening reports, but this was, I think it was 2 years ago, they implemented that we have to accept these portable screening reports. In the initial bill, they were valid for 30 days. It said they had to come from a consumer credit agency or something like that. I forget what the language was, but this kind of expanded that language. To us, it looks like a little more chance of fraud on there, like, and these are all tricky too when there's specific bills like this. If someone submits something that looks fishy to us, oftentimes in practice what we do is can you just fill out our application and we'll waive your application fee, and then we're actually looking at a report that means something to us. But we didn't see that really get a lot of traction. Like, we weren't seeing a lot of tenants forwarding on portable screening reports. But then this also addressed or kind of provided more language around you can't require a screening report from a Section 8 tenant. And that was sort of the case already. But I think the earlier language was more like you can't use credit score to determine qualifying a resident who is coming with a subsidy. And now it's just saying like you can't even require that or something along those lines. So it also added that violations can be fined up to $5,000. So maybe just trying to add teeth to some previous things. Those are the high points there.
Yeah, we're not in the property management business, but I haven't heard from our managers. I haven't heard much about this.
Okay. Question from Maria on House Bill 1236. Yeah, what does portable mean? I think maybe explain exactly what this means, Brandon.
Yeah, so it just means that what they were trying to go after here is I think tenants were saying to their representatives, like, I'm having to go, when I try to find an apartment, I apply at 10 places, it ends up costing me like $800, and that's not fair or something. And so what they said was like, well, yeah, there's no need for every single one of those places you applied for to need to pull your credit and charge you an application fee. So why don't we have it where you could pull at one place and share that around? So that's what they're basically meaning with this. So they were, I think there was maybe hope that there would then become these agencies where you go get a credit report. Zillow works a little bit like this. So that's probably the place where you see it the most. Of you can go basically get a completed application, and then you can just one click apply to a whole bunch of different places. And that had its own effect on, well, now an application to a property means a lot less than it used to, because someone hasn't paid any money and they may not have even looked through all the photos. It's just so easy to apply and see what happens. So
what percent now of your applicants bring a portable screening with them?
Very, very few.
So still like low single digit type?
Yeah.
Okay.
Like it's not gotten the traction that I think that was maybe expected. So I don't know if part of this is like people saying I didn't like how it was and you need to update. I really don't know. And it wasn't. Yeah, we'll see the effect of it, but so far it's been very minimal what we've seen from that.
And I like your comment, like, hey, if you, because I not thought about the fraud aspect of it, but I mean, that does not surprise me. So I guess your approach is, hey, if you get something and it just doesn't look right to you, you just say, hey, Mr. and Mrs. Tenant, fill this out, we'll waive it or pay it for you. And then you're eating $20 just to make sure that you have the accurate report.
Yeah, that's been what we found is the easiest solution there.
Adam asked, does this bill address the maximum income to rent ratio that can be required by a landlord?
No, to my knowledge, this didn't address that at all. There was a bill last year that did that, and that was what capped us at 2-to-1.
All right, moving on to the next bill, House Bill 25-1108, lease termination after tenant death. Tell us about this one, Brandon.
I'm not going to get into this a ton, but this just provides some language around what happens after a tenant dies. Can you hold their heirs, can you require them to pay the remaining rent on the lease and that kind of thing? And basically this is just some protections around that. So I don't think we don't have a ton of tenants dying in units, but it has happened. So yeah, it's like on our end, at least, it's like something to be aware of, but I don't think it changes a ton procedurally or that kind of thing.
All right, House Bill 25-1235, jury trials for tenant proceedings. Now, this is not passed, but Darren, I remember I think every 2 weeks, there's a workforce housing call. Darren and the board members sit on there. I join a lot, and it's insightful to me. But I remember you guys had a lot of really insightful debates about this.
Yeah, we weighed in on this one a lot. I mean, the big why here. I mean, I think at one level, I learned what a fiscal note is. So this one carried a massive cost burden to the state, which is obviously already in a budget deficit. But insofar as that it would have clogged up municipal courts that are already behind and needed, so they would have needed more money to support all these new cases.
It was like tens of millions of dollars, right?
It was a lot. I don't know how they got the math, but it would have easy to understand that if you could have called a jury trial to object to your eviction, that you would probably do so if you had that amount of time on your hand. But there's a lot of due process in the eviction process. I mean, you have a lot of ability to cure, and I just from a renter's perspective, I don't know what this was solving. And again, so it's worth monitoring, but this is an example of a bill that, we are going to seek to work on closely with the sponsors, understand what the intent is, and to see if we can come up with some alternate solutions that create a win-win. But this one would have created a huge mess. And I think the unintended consequences, when you add that much cost to the system, both on the landlord and on the state, I mean, that just continues to put upward pressure on rent.
Yeah. These are the kind of things that just, if something like this went through, makes it less attractive to be a landlord in Colorado. So we want people coming in to provide more supply here and wanting to develop new housing and that kind of thing if we're going to have affordable housing.
All right, another bill that did not pass but worth watching, House Bill 24-1057, the algorithmic rent setting ban. So tell us about this one, Brandon.
Yeah, so essentially here they were, this one really targets real page essentially. And I think the thinking behind here is that there are kind of these algorithms in play that so many landlords are using to price rentals that they're almost, like self-referential in this way that could be kind of price fixing. That's my understanding of what the bill sponsors are trying to combat. And the language in it just started to get, I think, I don't think they could come up with something that made sense, right? Because at some point, what is an algorithm and what is, is it a problem then to go on Zillow and look at what else is available for rent and use that information to set your own rent price? This one would have been a huge mess, and at least how it was written and some of the language that was in it. So we'll see if it's back. It didn't end up getting into law.
So this is an example of one where the Workforce Housing Coalition honestly didn't spend much time on this bill. The Apartment Association was spending a lot of time on this bill on behalf of big corporate clients that use algorithms or the algorithm tools. But for us, I mean, a lot of, for example, our portfolio, especially in today's market, which is pretty depressed, pretty renter friendly. We've seen when you have one of these pricing models, it really crashes rents. So on the other end of the spectrum, these things I think have probably made rent more affordable, which didn't catch any headlines on these bills. But this is one where, I mean, for us and most probably people on this call, they're not using some kind of revenue management tool and they're pricing manually. And so we kind of let the other associations duke this one out.
Yeah.
I think the veto was right though, because this again sent a pretty strong message nationally that Colorado would be, I think, the first state in the country to do something like this, and that's a pretty bold statement on our housing policy program in a negative way.
And just as a reminder here, Darren's mentioned on the last couple of bills and other bills that some we've discussed today, some we have not. The Workforce Housing Coalition has, they've gone out there and lobbied and worked legislators with. Make sure you do plug into the WHCcolorado.com website, join the email list. There's a donate button on there as well. But as Darren said, hey, stay plugged in because it is a coalition of a lot of landlords, professionals, and people that's all in the housing providing world to go out there and make sure that we can find the common sense with these bills as well. So stay plugged in at WHCcolorado.com. All right, I think that's the last of the bills we have on here. So We'll go to the Q&A here in a few minutes since we have a few minutes left of the webinar. But Brandon, walk us through this action checklist for Denver landlords. And it's probably for Colorado landlords too, right?
Yeah, that's very
so
cool.
Action checklist for Colorado landlords.
Yeah, because these bills are Colorado wide, right? So yeah, review your leases. Some of the things, there's maybe some new clauses around when a tenant dies in the lease. Specifically, I would say one thing that was no longer allowed is there was rent acceleration clauses in some leases that basically said if the tenant dies, all the rent remaining on the lease is due. That doesn't feel like a great way to do business, but those clauses need to go. But yeah, make sure you understand kind of some of the implications with the domestic violence, what clauses you may need there, specifically on your demands as well, and security deposits. Because a lot of things, if you have a lease that's, a decently old, you will find some like very landlord friendly things that just came kind of templated years ago. It was very common to see some things that like when you read it, you're like, wow, that's aggressive. And like maybe in practice, you're not really enforcing those or whatever, but I don't think attorneys would recommend having a bunch of like clauses in your lease that are unenforceable or specifically like, in opposition to newer legislation and that kind of thing. So review your leases, update ads, make sure you're complying with the fee bill and being very clear on all of that. Make sure you're accepting housing subsidies, not using credit scores against those tenants, and being willing to accept the portable reports if you get those, or just understand what your requirements are there. The evaluate pricing tools. Maybe this is something that's really only applies to like massive landlords using those tools. So I don't know. All the property management software, or a lot of the property management softwares that I'm familiar with and stuff, do have kind of recommended pricing things for renewals and that kind of thing. So you may just want to think if you want to kind of update your processes in the event that this comes down in some way, shape, or form in the future. And then we didn't even talk about the receivership bill, but that's something in here of it's a time to be on top of it and just make sure you're never in a position where
talk about the receivership bill first. Like what was it?
Yeah, so basically, I mean, this one, as I understand it, it kind of was targeting this whole issue around the edge at Lowry and the Venezuelan gang takeover, that kind of thing. And basically that thing blew up and it was this huge black eye on Colorado, and the landlord was not cooperative in working with the city or whatever to do anything about it. And so that's made a lot of headlines. I think even into last week or something, there was like an arrest warrant out for the owner of that or something. So that was my understanding, is like they were after that, of like the city wants to be able to, or the state wants to be able to do something when there's just something that's so poorly managed that it's really causing all kinds of problems and, costing the city a bunch of money on resources from their infrastructure dealing with this, and a landlord's not compliant. So in theory, they could take receivership of that building and assign somebody else to manage it. And am I doing an okay job?
Yeah, I mean, I think that this is a Senate Bill 20. I mean, look, we gave some feedback on it. The feedback we gave, I mean, I agree with the why behind the bill. I mean, there's some bad actors in our space for sure. There's some bad actors in every industry. And so, are all for giving city tools to clean that up. I think the worry is any potential overreach or being caught up in a situation where you, by virtue of something beyond your control as a landlord, you cannot cure, you cannot fix, you cannot do in say 30, 60 days. And so we were hoping to get some cure period, some reasonable cure period that still gave the city the teeth they wanted, but gave reasonably and well-behaving landlords an opportunity to fix it, whatever the issue might be, for which everybody on this call has probably dealt with something like this that's made operating your property very hard. So we'll see how that plays out. But this was definitely a sign of the times bill, and was the result of some national headlines that we were the unfortunate recipient of.
Brandon, can we send out these slides after the meeting? A few people are asking the comments.
I'm fine with that. Yeah.
Yeah, we'll send them out very soon after the meeting here. All right, so as we wrap up here, I'll get back to some final questions in the chat. So again, 2 calls to action on here. Great reminder for what Keyrenter does with their portfolio health audit. If you're an owner operator of your own portfolio and you want their help in looking at your portfolio, giving you feedback on there, help you understand the rent, potentially take it over, scan the QR code, reach out to them. Brandon's team of John and Sean on there are phenomenal members on Keyrenter's team on there. So take advantage of it because I think it's a great opportunity. And of course, go out there and get plugged into what the Workforce Housing Coalition is doing and support them whatever way you can with joining the email list, donating some money. We had our first event last night, which was a social hour between some of the workforce housing members and some legislators at the Colorado level, which was, I found, great to go to and just very interesting to go out there and talk to legislators. So lots of good opportunities up there. Any final thoughts or things you guys want to add on as we wrap up here?
I would say for the Workforce Housing Coalition, if you at the very least want to hop on and join the email list, there'll be something at the end of the summer to give kind of a broader overview of the upcoming legislative session and strategy. And that would be some kind of webinar, and you should attend that if you're interested. But I would just encourage everybody to get involved in some way, shape, or form, either through the Workforce Housing Coalition or building a relationship with your legislator, because I think for a number of years, legislators didn't hear from landlords. So they got kind of one side of the story. And I've found that 99% of the people in our business are really great and really well-intended and care a lot about our renters. So they need to hear more from us.
I think it's kind of new to me to actually get involved. Like that event last night, was able to meet some representatives and that kind of thing. So if you have any inclination to that, certainly your representatives, I think, want to hear from you. And my understanding is they work pretty hard through the legislative session, which is kind of January to late May or early June. And then this is sort of their summer when they're, I think, a little checked out and probably just taking a breather from that. But then in the fall is really when it kind of ramps up. And I think that's when is probably your best opportunity that they'll sit down with people, they'll talk to you. There's room for engagement there. There's events happening, town halls, these kind of things. And then all the bills, really a lot of the drafting of these bills is in that fall period and into the winter. They have to submit them all sometime in December or something like that. So now's a lot of the time to coming up to get involved here and that kind of thing.
Great. All right, I know we got about 5 minutes left and we'll wrap up here, but just I think do some general questions here, and I'll maybe do some rapid fire to you, Brandon. Do you have to accept vouchers in the state of Colorado? Like Section 8 housing vouchers?
Yes, that was from a year or two ago. Yeah. They made that statewide. It may not work for your property. The rent may be too high, kind of thing. You don't have to lower the rent to accept it, but you cannot discriminate. How the language ended up working is you can't screen based on source of income. So you can't say, I don't like where your money's coming from, is how they view that. So
what is the best source for the latest lease addendums? Probably your lawyer, right?
Yeah, I mean, we rely heavily on Cheddar Salzer-Muccio, is that the current name? TSM, I think, is .com, maybe is there, tsmlaw.com. They've been a great resource over the years for just helping landlords stay compliant and have up-to-date documents. And they've historically had a lease that you can just buy that'll reflect, their best understanding of the current situation.
Carla asked, is there a new law about occupancy limits being abandoned, or is that a municipal decision? I think last year, they signed in
the last session.
Yeah, that there were no longer the occupancy limits. Go ahead, though.
Yeah, exactly. So there are no longer occupancy limits except those imposed for safety reasons by like the fire department and that kind of thing. So you still have to kind of understand how those work in the individual areas. But I think that was a big win for the people that were wanting to provide some kind of student housing, and they'd be in these there'd be an HOA or a municipality saying you can't have that many people, kind of thing. So yeah, that's in full effect.
I don't know. I haven't heard about a new law abandoning it. I know like Fort Collins and the other municipality, they're pushing back on it some form or the other. I think it's one of those like developing topics. I mean, Fort Collins, as far as I know, they had like the most restrictive with their, I think, UC +2 or UT +2 code up there. And they enforced it actively as well. So I don't know about any laws, but I think that's just an active thing. As I've talked to a lot of people who do like room by room rentals, they're following that actively. Great. Well, I think we answered all the questions on here. If we missed any, please reach out afterwards. Of course, we can't give legal advice, but if you have direct questions about, managing your properties or anything like that, reach out to Keyrenter. They are a full service property management company. And of course, if you want to go out there and have your voice heard with the new laws being considered and proposed at the state level, please plug into the Workforce Housing Colorado, the Workforce Housing Coalition website at whccolorado.com. So thank you for coming out. We had a jam-packed webinar room day, which was great. And then Brandon and Darren, thank you guys for taking a chunk of your Friday afternoon with us.
Yeah, absolutely. Appreciate it, everybody.
Thanks, everyone. Enjoy the 4th of July, and we'll keep bringing you updates on what's going on.